When we think of DUI cases, we usually think that there's a police officer who pulls over a driver. The officer has the driver do some field sobriety exercises. Then the officer arrests the driver and makes them do a breath test. Of course, the driver is warned that if they don't submit to a breath test, their license will be suspended for at least 1 year. But that's not necessarily how every case goes. What happens if a police officer finds a person who appears impaired but wasn't actually in the vehicle? Those are situations that might seem like it's common sense that a person standing right next to a car was the driver, but the law is a little more tricky. This is a scenario faced by one of my clients recently. An officer responded to an area and found a car parked under a bridge. The defendant was standing 15 feet away. The officer smelled a strong smell of alcohol coming from the defendant and the vehicle, and so he believed that the defendant drove while he was drunk. The officer arrested the defendant, who then refused to perform a breath test. Needless to say, under Florida law, his license was suspended. Now, normally this is the end of the story, but here's where it helps to have an attorney who really knows the law. An officer can make a warrantless arrest for a misdemeanor DUI in any of the following 3 circumstances. Number 1, the officer personally witnesses each element of the crime of DUI. Number 2, the officer is investigating a crash, and during the accident investigation develops probable cause to charge DUI. Or, one officer calls another officer for assistance, and the combined observations of the 2 or more officers are united to establish the probable cause. This is sometimes called the fellow officer rule. Now, we can see this rule found in Florida Statute 901.15, and there's also an abundance of case law on the subject. If you check out my blog, I've got all of the citations, so if you're interested, you can look it up on your own. But what this basically means is that the police aren't allowed to arrest someone for a misdemeanor DUI if the facts don't fit into one of these 3 circumstances. Now, today, we were extremely excited to learn that the Bureau of Administrative Reviews at the Department of Highway Safety and Motor Vehicles agreed with us in this case and set aside my client's suspension. My client should have never been arrested in the first place because there was no evidence to place my client in the actual physical control of the car, and therefore, he should have never been asked to do the breath test. As a result, we were able to successfully get his DUI suspension of his driver's license set aside, and today he can drive again. If you're arrested for a DUI, there are major consequences for your driver's license, but there's also a criminal case to deal with. Make sure you have an attorney who understands the law and can help you make wise decisions in navigating all of the issues for your case. Remember, you can always call or email my office for free advice.